Welcome, everybody. Thank you, thank you, thank you for all your incredible patience. We're going to be moving quickly so that we can try to catch up on this presentation. And welcome to the last webinar in our three-part series, Challenging Sexual Violence Against Immigrants in the Workplace. My name is Debbie Smith. I work at the International Office of SEIU in Washington, D.C., and I'm an Associate General Counsel in Immigration Law. And thank you so much for bearing with us with all of our technical difficulties and taking time away from your incredibly busy day to think about how to challenge sexual violence in the workplace. And we're going to be focusing today on what are the remedies for immigrant survivors of sexual violence. Maria, can you change the slide, please? Great, thank you. But before I introduce our amazing speakers, I just want to let you know and remind you, because if you've joined our other webinars, you've already heard this, of the purpose of this webinar series. And it's beyond learning the important tools we've talked about for identifying immigrant survivors of sexual violence in the workplace and best practices for working with immigrant survivors. Now we're going to be talking about the legal remedies for immigrant survivors, but we have a bigger goal, we have a broader goal, which is to develop partnerships between unions and anti-violence. I can hear background noise. Okay. And anti-violence advocates by bringing together allies and creating ongoing collaborations in order to create best practice models and long-term partnerships to prevent and respond to sexual violence in the workplace against immigrant survivors. And we'll talk about this again at the very end. Sonia's going to be talking about it when we get to the conclusion. Can you change the slides, please, Maddie? Okay, good. So I want to introduce, and I'm excited to introduce this great panel, and I'm glad we were able to get to it today and not have to cancel. Our first speaker today is going to be Eunice Cho, and Eunice has been working on immigration issues and policy and civil rights challenges to immigrant detention for many years. She's specialized in labor and employment law. She's worked with the National Employment Law Project, NELP, and she's the co-author with another one of our speakers, Monica Guizar, of a toolkit, California's New Immigrant Worker Protections Against Employer Retaliation. So thanks, Eunice. Are you there? Hello, Eunice.
Thank you.
And Kay-Chin Locke. Kay-Chin is our fabulous attorney at SEIU Local 32BJ. She represents workers in the greater New York City area, and her practice includes legal support for the union's organizing and legislative campaigns, labor and employment litigation, immigrants' rights, collective bargaining negotiations, and labor arbitrations. Thanks, Kay-Chin, for hanging in and participating today.
No problem. Hi, everybody.
Hi, Kay-Chin. And Lauren Bond has been on all of our other webinars. Thanks so much, Lauren. Lauren is an alumni of SEIU. She's currently the legal director of the ACLU of Kansas. But before joining the ACLU, Lauren was our incredible Assistant Attorney General at SEIU International, where she provided legal support for the union's Fight for 15 campaign. And she's represented low-income workers in employment and civil rights litigation, including voting rights cases in Alabama and Northern California. Welcome, Lauren. Thank you for participating.
Thanks, Debbie.
And we have also Monica Guizar, and Monica is a fantastic attorney in Los Angeles. She's an attorney and shareholder with the union side labor law firm Feinberg, Rogers, and Rosenfeld. And Monica represents labor unions, workers, labor management trust funds, and nonprofits. And she's done this work for many years and done incredible work. And I hear an echo. I hope everybody is on regular phones so we don't have the echo. Monica also provides legal advice and assists with policy analysis to local unions, labor federations, and international unions on immigration reform at the state and local level. And she's done incredible work in legislation in California, and she's going to be talking about some of that today. Hi, Monica. Thanks for being on the call.
Hi, thank you.
And we have Jeremy Simmer, who is a strategic researcher with SEIU at Local 49 in Oregon. His work informs organizing campaigns and policy initiatives to create good jobs in janitorial, security, healthcare, and other industries. Welcome, Jeremy.
Thank you.
Sonia Paras is the president and co-founder of Assista. She's also in private practice in Iowa. She's played an amazing role in many of the early efforts to figure out how to combine workplace immigration protection with immigrants. And she worked on helping detained immigrants in one of the largest raids in U.S. history in Postville, Iowa, and filed close to 50 U visa applications and was very, very successful in this important case. Welcome, Sonia.
Thank you.
So next slide, please, Maria. So today we're going to focus on what legal remedies, what options there are for immigrant survivors of sexual workplace violence. We'll start off with Eunice talking about immigration remedies. We'll then move to Lauren, who's going to talk about protections provided by the EEOC in Title VII. We'll then move on to Kachin, who will be talking about how unions make a difference and provides protections against sexual violence in the workplace, and she'll look at some contract language. Monica will be talking about the campaign to provide on-the-job protection for immigrant women workers that combine community and labor organizing with legislative work. And Jeremy will be talking about his work in helping pass an important Oregon statute, an important Oregon law that helps protect immigrant janitors from sexual violence in the workplace. And Sonia will conclude with information about best practices and resources available, including some of the contacts for DV organizations and advocates around the country. So thank you, everybody. Let's move on and jump in. And our first speaker will be Eunice, who will be talking about protecting immigrant survivors with immigration remedies. Thanks, Eunice.
Great. Thanks, Debbie. Again, my name is Eunice Cho, and I'm an attorney with the ACLU Washington right now. I am going to be talking about protecting immigrant survivors with immigration remedies. Could we go to the next slide? So briefly today, I will be providing an overview of our humanitarian visas that are available for victims of workplace crimes, and this includes U&T visas. Talk about some examples of what to look for when deciding whether or not this might be available for folks that you work with, and some best practices for organizers and advocates around U&T visas. And we focus on U&T visas because this remains one of the only remedies, it's definitely not the only remedy, but one of the remedies that are available for victims of immigrant workers who are victims of retaliation in the workplace. In the past, there were some additional administrative remedies that might have been available under the Obama administration, but we are finding under this administration that is much more difficult to obtain. So why do we want to actually pursue immigration protections for workers? There are many reasons, including having immigration protection obviously supports workers to come forward and report abuse that happens on the job. It can protect vulnerable immigrant survivors from deportation, and this also includes dependent family members who might be able to get immigration protection as well. The worker actually gets work authorization if they do not have it at that point. And working this into an organizing campaign often creates a victory in terms of being able to gain protection for workers who come forward, and it can strengthen relationships with local labor agencies who you're cooperating with. The next slide, please. So T visas, in short, they are temporary non-immigrant status that provides protection for certain victims of human trafficking to live and work in the United States for 4 years. And the good thing about T visas is that the person who receives a T visa can actually adjust their status to a legal permanent resident and ultimately become a U.S. citizen after the completion of the case. It also provides protection for dependents, so family members, minor children, and spouses as well. Next slide. In order to get a T visa, the person needs to have been a victim of a severe form of trafficking. That includes sex trafficking, which is often the kind of most familiar way of trafficking in the media, but most relevant to us is labor trafficking. So those are forms of involuntary servitude, peonage, debt bondage, and slavery. And we'll talk about that in a little bit more detail in a moment. So the person needs to be a victim of labor trafficking, has to be actually in the United States because of the trafficking itself. And this is really important for folks to remember, is that the person needs to actually cooperate with law enforcement and show that they will suffer extreme hardship if they're removed from the United States. Next slide. So what is it when we're looking for trafficking, involuntary servitude, or peonage? In general, what I would recommend practitioners look for, and this is for organizers or people who are working with people in the, who are victims of trafficking or involuntary servitude or peonage, generally it is looking for facts that would show that somebody has been compelled or induced to be engaged in labor. And this includes the recruitment, enticing, harboring, or transportation of another person. So this can also apply to labor contractors, people kind of up and down the chain of command. But really, when you're looking for an indicia of trafficking or involuntary servitude, these are some helpful facts to look out for. Have there been threats of physical or psychological harm to the person? And this includes reputational harm in terms of threatening to spread rumors about somebody in their home community, threats to contact law enforcement or immigration to compel work. So this comes up quite often. Has the employer said, I'm going to call ICE on you if you don't do X, Y, Z? Taking somebody's identity documents, passports, or travel papers. And then also kind of the other types of facts that would indicate some sort of coercion and abuse taking place. So non-paid wages, inadequate food or housing, lack of medical care, clothing, verbal and physical abuse by the boss, restricted contact with the outside world, uses of locks and fences to keep somebody inside a place of employment. So those are all sorts of things to look out for. Next slide. A U visa is a form of immigration relief that provides lawful status for up to 4 years, work authorization, and the ability to adjust your status to a legal permanent resident for victims of crime. And this applies to only certain types of crime. Next slide. In order to actually qualify for a U visa, you have to be a victim of a qualifying criminal activity. You have to be helpful in the investigation or prosecution of this criminal activity. So you actually have to work with the law enforcement agency and have certification from the law enforcement agency that you have been cooperative in these investigation or prosecution. And this includes the detection of the crime. And this can include different law enforcement entities, including more traditional law enforcement entities like the police, but also I think relevant to our discussion, the EEOC, the Department of Labor, the NLRB, or state equivalents. The most important, the other thing that you have to have shown is that the person has suffered substantial physical or mental abuse as a result of the crime. Next slide. So there are a certain amount of qualifying criminal activities that the law requires that you must have been a victim of in order to qualify for a U visa. And you see those on the screen. And in red are the ones that I think most typically come up in the workplace context. So there are sexual violence related crimes like abusive sexual contact, rape, sexual assault. There's procedural types of crimes like extortion, obstruction of justice, and perjury. There are felonious assault when workers are actually abused on the job. And then the kind of inducement and trafficking types of crimes like involuntary servitude and trafficking. Next slide. So here are some things to look out for when you might be encountered with workers who you might think would be eligible for a U or a T visa. For U visas, we look at sexual violence in the workplace. So crimes include abusive sexual contact, rape, sexual assault, and sexual exploitation. This also includes the attempt and conspiracy and solicitation of these crimes. So attempted abusive sexual contact or sexual assault can also be included. I would recommend that if you're an attorney working on this area, look at local and state statutes around sexual violence. And I think often for these types of criminal activities, it is helpful to report to local police if you have a friendly jurisdiction, or the EEOC. Those are the types of fact patterns that they're most familiar with. Next slide, please. Another class of crimes is the procedural crimes like extortion, obstruction of justice, perjury, and witness tampering. And for those, I would ask questions like, has an employer ever intimidated the worker, threatened them to delay or prevent testimony in official proceeding? And that includes a wage claim. Has the employer ever altered or concealed records? This includes employment records, timesheets, that sort of thing. Has the employer ever tried to prevent a worker's communication to authorities? Or has the employer ever threatened to expose immigration status, damage property, or harm the person to delay somebody's participation in an official proceeding? So this could include threatening to call ICE if the worker has demanded their back wages, that sort of thing. Next slide. A new crime qualifying criminal activity in the U visa statute is fraud in foreign labor contracting. And so that is an important one to look at, especially with workers who are brought on different types of visas, such as H2A, H2B types of visas. New qualifying criminal activity if the employer knowingly and with intent to defraud recruits, solicits, or hires a person outside the United States under fraudulent pretenses. So this is really helpful when the employer might have provided false representations to a worker about what the work actually will be like, if they're going to be provided housing, whether they have to pay fees to labor brokers, food and transportation, those types of things. So for cases that seem to be exploitative contract work positions but don't quite rise to the level of trafficking or involuntary servitude, it's helpful to look for fraud in foreign labor contracting. Next slide. Who can certify for a U visa workplace crime? I think it's really helpful to remember that workers who have investigations or complaints to the Department of Labor, Wage and Hour Division, the EEOC, the NLRB, and state agencies such as the California DLSC, DFEH, the New York Department of Labor, and the Illinois Department of Labor, as well as local law enforcement agencies. This includes city workplace agencies, but also police departments can often be helpful if you're in a friendly jurisdiction. And if you have a claim actually before a judge, they can also certify for a U visa as well. Next slide. So quickly, best practices and tips for folks. If you see a case that looks like may be possible to have a U or T visa, start documenting facts immediately. And I would really consult with both immigration and employment lawyers for assistance, because this is really on the intersection of both immigration and employment law. Another really important thing to do is document any physical or psychological impact of the employer's actions on the worker, because one of the things that you will have to prove is that the person has suffered substantial mental or physical abuse as a result of the crime. And oftentimes we don't think about that until too late in the game. So it's really important to really think about those questions early on. And also develop relationships with friendly law enforcement agencies. So this includes the Department of Labor, the EEOC, and talk to them about these types of immigration remedies that are available. Next slide. So I really appreciate you all listening to this part of the webinar, and I'm excited to hear the rest of the presentation.
Thanks, Eunice, and thank you guys all for being on today. And I'll apologize in advance. I'm in kind of an echoey hallway, so just raise your hand or chat if it is hard for you to hear me. So I want to talk a little bit today about the role of the EEOC and kind of what happens after you file a charge with the EEOC, or after a worker reaches out to the EEOC to initiate an investigation, and kind of how that interplay will work with organizing a workplace where that it doesn't already have a union contract. And so, this is something that came up a lot during the Fight for 15 campaign. We were going into these restaurants where workers didn't have CBAs, they didn't have any protection, but they did have a union, and they did have a lot of workers who had their back. And when they were experiencing an issue like sexual harassment or sexual violence, they wanted to have, organizers and workers were really eager, I think, to lift this up and do all the things that organizers and union leaders know how to do in order to amplify issues and hold employers accountable. And so this section of the training is hopefully just to give you guys a little bit of insight on kind of what the limits of that are, and kind of what are acceptable ways that you can work with both the EEOC and using your normal organizer tools and tactics to really blow things up and to really hold employers accountable for improper conduct. So next slide, please. So in some of the previous trainings, and I know not everyone's been on all the previous trainings, we've kind of discussed what the EEOC is, what it does. I'll just do a quick refresher here on both what it is and what the process is. So the EEOC is just the federal agency that enforces sexual harassment and discrimination laws. It's the gatekeeper to federal court. So you can't go into court and just file a Title VII action for sexual harassment. You're going to have to go to the EEOC, or in some cases, the state agency that's the EEOC, so FEHA out in California, before you can go into court. And so the process is the worker is going to sign and file a charge. The charge is assigned to an investigator. The investigator interviews the worker and witnesses. The investigator is going to interview the employer. And then the EEOC, normally it's going to try to reach some kind of informal settlement or a formal settlement. In some cases, they will decide to sue on behalf of the worker. And in other cases, they'll give the worker a right to sue letter, and then the worker can go forward and sue in federal court if they'd like. Next slide, please. And yeah, just as a refresher, here's kind of the breakdown of where the EEOC offices are. They're actually in a lot of places, but unfortunately, if you're working in a rural space, it's very hard to get workers into the EEOC. But for the most part, there is pretty good coverage. Next slide, please. So this is a video. I don't know if it could be played, but it's from our Fight for 15 campaign. A couple years back, we did a sexual harassment field program. And this was really something that was born out of conversations organizers were having with workers that they were speaking to. This was not an issue that was originally on our minds or something we wanted to, hold McDonald's accountable for, but it's something that workers were definitely experiencing. And so I don't know if the video works. Or if it's, okay, no. So we can just move on. But so the video, the point of what I was hoping to show with the video is just that workers, I think, want to tell their stories. And you all as organizers are in this really unique position where you know how to bring workers together, and you know how to help them tell their stories and help them come together and get what they want. And so one of the reasons I think that this is, it's really important that a role you organizers can play in all this is bringing workers together. And so one of the reasons I think that's important, beyond just the fact that workers are going to have more support in their workplace when they come forward, it's also going to make your case stronger at the EEOC. And so I mentioned this in some of the previous trainings, but the EEOC is more likely to be interested in the case, and more likely not only to seriously investigate the case, but also to bring a lawsuit on behalf of workers if there's a lot of people involved, if they're going to see impact. And the best, easiest way you can show impact is to show that a lot of workers are being affected by this issue. And so that kind of brings me to the next point of how do you do that, right? Like, you guys, for all of you organizers on here, you know how to bring workers together, you know how to get them to tell their stories. So you can kind of do your normal organizing tactics, but there are a couple things I want to raise. Next slide, please. So normally when there's a workplace issue, you do a speak out, you have workers do a sit-in, you have workers, in unorganized workplaces, you're going to do some kind of action, some kind of direct action where people are all coming together and talking about it, which is great. And that's going to give other workers the courage to tell their stories. It's going to, potentially bring in press attention to this problem that's going on in the workplace. The sexual harassment and issues that are pending before the EEOC are a little different. So I think these are definitely still actions you can take, but it's important to remember that, we're asking the EEOC to pull together in the best case scenario, pull together a federal court case against the employer. And so when they're building their case, they're not going to want a lot of information, out there that's not helpful. They're going to want to make sure things, information that they want to use is confidential, and they're going to want to make sure that they're able to have the best investigation possible where workers and potential witnesses aren't flipping their story based on what they've heard from other people. And so next slide, please. Next slide, please. Okay. So basically, it's important that workers know that they're able to come forward and talk about harassment that they're experiencing. And so there are two laws that protect this right. So there's the Title VII right to come forward and complain. So in Title VII, there's this thing called the opposition clause. And that makes it unlawful for an employer to discriminate against an employee because the employee has opposed any practice made unlawful by Title VII. So that's, a situation where an employee comes forward and complains about discrimination in their workplace, comes forward and complains about sexual harassment, lack of an accommodation under the Americans with Disabilities Act. Well, that's a little different, but most of these anti-discrimination statutes have protection against retaliation, and Title VII is the opposition clause. And so a person can oppose by responding to someone else's question just as surely as they can by provoking the discussion. So this basically gives protection for workers who come out and say "me too," which is what we're seeing happen now. And so basically this is saying that if a worker wants to come forward and say this happened to me or I saw this happen to someone else, they're going to be protected by the Title VII opposition clause to the same extent as the worker who raised the issue in the first place. Back in 2016, the EEOC provided more guidance on retaliation and the opposition clause, and it said specifically that it includes a whole bunch of different things that workers are going to do anyways, and that workers who are organizing their workplace are going to do, including down here at the bottom, ticketing or an informal public protest. These two things are covered and protected by Title VII, and so any retaliation that a worker experiences, whether they're doing this on behalf of themselves as a victim of sexual violence or on behalf of a coworker who is a victim of sexual violence, it's going to be protected, and an employer cannot retaliate against them without incurring more liability. Next slide, please. And so there's another law that protects against retaliation for speaking out and coming together, and that's the National Labor Relations Act. So Section 7 of the National Labor Relations Act has been interpreted to protect workers who come together and who are talking to each other about issues of sexual harassment and discrimination in their workplace. So this case that I threw on the slide, Fresh and Easy Neighborhood Market, it was ultimately decided unfavorably because the person who was going around and asking for support in her sexual harassment claim was, doing it in a way that was bothering people, and so they found that the employer had a right to, discipline her and follow up with her and ask her about her activities. But the underlying point that came out of this case was the board said that an employee is engaged in protected concerted activity when they're going around and they're doing these things. And if a worker is going around and asking, other coworkers, did this happen to you too? Or, can you be a witness for me? That's going to be protected Section 7 activity because they're talking about a workplace issue and they're trying to bring people together to help them and support them deal with a workplace issue that's problematic. Next slide, please. So those are the two laws that protect workers from two two specific laws that were federal laws that protect workers from retaliation when they speak out and when they're trying to organize their coworkers to confront sexual violence in their workplace. And so, this is what we wanted. We want organizers to know. You can have a speak out, you can circulate a petition, you can do social media on stories that you're hearing from workers and on stories that are happening. However, I think it's really important that, lawyers, if you have a lawyer on your campaign or at your local, that they have a chance to look at anything you're going to put out, not only to make sure that the worker's case isn't compromised in any way, but also to make sure that, all the things that we want legal to review is still, all the reasons we want legal to review other information is good in these materials. So before you put anything out, just make sure you run it by a lawyer and make sure that, they understand the action plan and have a chance to raise any concerns that might come out of this. Next slide, please. So, when we were doing our field campaign with the Fight for 15, I think the most common, question that came up was, the first one was, hey, can we do something about this? Can I hold a store action? Can I tweet about it? Can I do a press conference? Which, like we just said, the answer is yes, workers are going to be protected. But the second question is, oh, well, we filed an EEOC charge at this point. Can, a worker talk about it? There are reporters who want to ask her about it. She wants to say something to her boss, during a speak out, how is this going to impact their EEOC investigation? Next slide, please. And so the answer to that is, you can do it. It's fine to do that, but there are situations where there can be things that workers say or things that are done during these actions that aren't helpful for a worker's EEOC case. So you want to make sure, you want to obviously make sure that you're consulting with a lawyer. And then also the reason a lawyer is very important to have involved in this, specifically if you have a lawyer who's representing the worker in connection with their Title VII or their EEOC charge in Title VII case. You want to make sure that the workers aren't providing facts that are inconsistent with what it went in their charge or what they said during their EEOC interview. Another thing you want to make sure of is you want to make sure that workers who speak out, have actually filed a charge for extra layer protection. So speaking out is going to give you that protection from retaliation, but if you can paper it up, you're always going to be in a better situation as a worker, especially if it's going to be, the EEOC that's investigating the retaliation claim under the opposition clause. Next slide, please. And so another thing that came up when we were running this field campaign in the in the Fight for 15 was EEOC gag orders. So as I said, generally there's no problem with speaking out after you've filed an EEOC charge. We just want to make sure that you're not providing inconsistent information or unhelpful information. But sometimes the investigator, they might tell the worker that they shouldn't be talking to anybody about their case. And so there's a reason they do that. They might be doing it to make sure that they're preserving the integrity of the investigation. If the organizer or if the investigator hasn't had a chance to talk to other people and interview other workers in that store or in that shop, they're going to be saying that, they want to make sure that they're not getting some tainted version by hearing too much information. Or they might want to maintain confidentiality before litigation. It might be a situation where they're like, this is a good case and, we don't want some facts that have been confidential and only shared with attorneys at this point to be disseminated widely. And so I think it's important, if a worker comes to you and wants to speak out, wants to do the speak out, wants to talk to the press, that you ask them specifically about, did the EEOC investigator tell you not to talk to anybody about this? Because we want to make sure that we're not doing anything to piss off the EEOC investigator. They actually have a lot of, as I mentioned in previous trainings, they have, quite a bit of discretion in determining, whether a case gets to their legal department and gets to be litigated and, how cases are assessed. And so it's very important that we, if you are working with a worker who has filed an EEOC charge, you're respecting the EEOC investigators' wishes and playing nice with them and making sure you're keeping a good relationship with them. Next slide. And so another thing that I think has come up a lot, or came up a lot when we were doing this in the Fight for 15 campaign, is that a lot of employer policies prohibit workers from talking about confidential, like, personnel investigations. It comes in a whole bunch of different forms. And so a lot of organizers and workers would look at their handbook, to the extent they still have their handbook, they would see that and they'd say, oh, maybe I'm not supposed to talk about this. And so while I just said, EEOC gag order, probably respect that, I'm going to say, if there's an employer policy prohibiting this issue, don't respect it. Next slide, please. And I'm saying don't respect it because it's under most cases, any provision of an employer's handbook or any employer rule, it's going to be it's usually going to be unlawful. Employers, usually have these kind of rules saying, you can't talk about ongoing investigation. But these rules have been held unlawful by the National Labor Relations Board many, many times for being vague and overbroad. This is going to chill Section 7 activity. Workers have the right, have an almost absolute right to talk about what's going on in their workplace and to talk to their coworkers and to talk to the media and to talk to organizers. And so a rule like this that says you can't discuss an ongoing investigation is most likely overbroad, it's most likely vague, and it's most likely prohibiting a worker from talking about something they are entitled to talk about. So this is a situation where, as an organizer, if you file NLRB charges, I would encourage you to file an NLRB charge, both challenging the rule and challenging any discipline a worker faces for breaching this rule. But also, just encouraging workers to know that, that these rules shouldn't be restricting them and that they have a right to talk about this, notwithstanding the fact that these policies exist. So that's kind of, I've been jumping back and forth between the EEOC and the NLRA and the NLRB, and hopefully it hasn't been too confusing. But I think the main takeaway should be that workers have a lot of protection in these situations by two federal agencies under two federal laws. And, I think there's a strong, that Congress, when passing these laws, recognized that there is a strong interest in having workers speak out and speak to each other when these issues come up. And so, I'll just reiterate again, as organizers, you know how to do this. You know how to get workers to tell your stories, tell their stories. You know how to get workers to talk to each other. And you know how to make workers stronger together in these situations. And so I'll just say that, hopefully if you take one thing away from the last 15 or 20 minutes of me talking, I hope it's that, that workers are going to have legal recourse if they're retaliated against, if they come out and they speak together and, they're doing all the things that are inherent in an organizing campaign. So I think that's it. Next slide, please. Yeah, so that's it for me, but thank you guys for listening. And if you have any other questions, feel free to reach out and email me. But thank you guys so much for taking time.
Thanks, Lauren. And Kachin?
Sure. Go ahead and get right to the next slide. So I'm going to talk about what a union contract and union representation can do in terms of protecting workers from sexual harassment. And the first thing I'll talk about is the sort of substantive collective bargaining agreement provisions that we've been able to get into our contracts and just sort of and that are sort of best practices. So it obviously, a sort of basic prohibition against harassment and retaliation, a reporting and investigation protocol are all things that you would want to see in the agreement. And Monica is going to get into more detail about an example of a really good one that was USWW, I think, helped negotiate. But that's a basic prohibition that you want. And I would also suggest not simply reciting harassment or discrimination based on protected classes, because those, even in arbitrations, can be a little harder to prove. And so you might want to think about doing a sort of more broadly worded anti-harassment or something along the lines of respect in the workplace, because, intimidation can take the form of some kind of express reference to gender or appearance, etc. But it also is just, belligerent, yelling, awful behavior that an arbitrator, especially a lot of our older, whiter arbitrators, don't recognize as having a racial or gender implication. They might find it more of a violation of a sort of more general anti-harassment or respect in the workplace kind of provision. The other thing to keep in mind when you're negotiating a harassment provision, including how grievance and arbitration is going to work, you want to be careful that you're not waiving workers' rights to file administrative or legal claims. I don't know if we've got lawyers on the line, but you should all read the Payette decision. You want to avoid language that sort of locks workers into just the grievance and arbitration provision. So the second substantive provision, obviously, is training requirements. The union has the right to negotiate, a requirement that the employer provide training or allow the union or some other expert to come on the property periodically to provide training. That's fairly straightforward and can be really effective. Right to information provisions. This obviously is not only something you can include in the CBA, but the unions have a right under the NLRA to information that's relevant and necessary to our role as collective bargaining representative. But you could codify that into a CBA provision to sort of expedite things, go to the arbitrator as opposed to the labor board. I talked about the grievance and arbitration procedure. Language access is something that, particularly if we're talking about immigrant victims, is something good to include. Employers aren't always the most, sort of sophisticated or enlightened about the need to have workers be able to actually understand what's happening in the grievance process, or in order to file, a complaint under the employer's protocol, they should be able to do it in a language that they are most comfortable in. So that's also something, substantive provision you should think about doing. Leaves of absence provisions are important. Obviously, there are, FMLA and disability leave protections under the law, but I think it's always good to codify some version of this. Makes it a little easier for people to access. You may not have to jump through all of the hurdles that you would otherwise have to in the statutory setting. Legal Services Fund, providing free legal services to employees is another good thing. Obviously, health fund coverage for counseling, treatment, that's fairly obvious, but people don't often think about the need of treatment for victims of particularly assault. But having access to, affordable and meaningful health insurance is pretty key. Lauren touched on the sort of, campaigning that workers and unions and activists can do around this issue. So one thing you want to think about when you're negotiating or renegotiating your no strike provision is making sure you're not waiving the union or the worker's Section 7 right to engage in other types of activity besides strikes. Employers have often come to us with very broad no strike provision proposals that would ban any kind of, leafleting or sort of non-picketing type of activity that would interfere, or prohibitions on the members' ability to speak about workplace issues to clients of the employer. So you want to be careful about, limiting the no strike provision so that you're not waiving effectively the right of the union and the workers to do a campaign around sexual harassment. Because we definitely, 32BJ represents workers in the cleaning and other sort of building service contracting world. Going to the client is one of the most effective ways of addressing any workplace situation, including sexual harassment issues. And I'll give an example of how that worked in a little bit. Some other points about CBA provisions. I would be interested in talking to folks at the end of this about experiences of processing grievances and arbitrating sexual harassment complaints that involve member complaints against other members. It gets a little more tricky. It doesn't have to be as tricky as a lot of union reps think it is, but I'd be interested in talking about how people have navigated that and the sort of protocol that you've adopted in the context of investigating or arbitrating those claims. see. There's one other point I wanted to make about the CBA provision, but now I'm forgetting what it was. You can go to the next slide. So Lauren has touched on some of this stuff. You know, unions can be part of any kind of campaign around sexual harassment. We have a right to information that help us undertake our grievance investigation. Workers have a Section 7 right to protest workplace harassment. Filing a grievance is a Section 7 right. So the NLRA obviously is a good tool for this. The example that I'll give you guys about how the CBA and NLRA rights sort of work together to help get a supervisor fired happened in Pittsburgh not too long ago. We had a union member who had complained to the employer about being sexually harassed by a supervisor, and she wanted as a remedy that the supervisor get fired. The employer undertook its investigation, determined, you know, for whatever reason that they didn't think the supervisor deserved to get fired, and so she filed a grievance. So, you know, we then undertook our own investigation, but as part of that, we asked for records going back 3 years for any other complaints and the results of the investigation of those complaints regarding this particular supervisor, because we had heard rumors, although no other worker had come forward, that this guy had a pattern of this, and we knew that establishing that pattern would help us make the case that you know, his conduct was sort of severe and pervasive enough that he deserved to be fired. The employer refused to turn over the records, so we ended up filing a labor board charge with the NLRA, because obviously we had a right to that information related to our grievance investigation, but also even absent the grievance, we would have a right to get that information pursuant to just our sort of right and responsibility to ensure a safe workplace for our members. So don't think you can't get it unless you've got a grievance filed. You absolutely can make an affirmative request even absent that. The board ordered them to turn over the records, and it caused the employer to sort of review the history with this guy, which, you know, for whatever reason it had chosen not to. At the same time, we and workers went to the building manager where this worker was employed, because even though he isn't the direct employer of the contracted employees, he effectively oversees them, but also has an interest in making sure that the building is safe for everybody. And so we did a little campaign with the client, and all of that combined finally caused the employer to see the light, and they fired the supervisor. So it was sort of a victory of, you know, workers in motion, CBA language, and exercising NLRA rights. So that's what I've got. These, I think, other folks are going to talk about. This is just sort of a checklist. Lauren's talked about the rallies. I think Jeremy's going to talk about some sort of policy ideas, but these are obviously other things that the union can assist members with.
Great. Thanks so much, Kate-Chin. Next slide, please. Kate-Chin, did you want to talk about this? Oh, okay. So we'll move on. Monica, thanks so much. You're on.
Sure, thank you. So I'm going to talk about a campaign that incorporates legislation and union contract bargaining and public actions with respect to changing the industry in terms of the janitorial industry and highlighting the issue of on-the-job sexual violence and harassment. So next slide. Next slide, please. Thank you. So I think, as was mentioned earlier, our law firm represents a statewide union in California, SEIU, United Service Workers West, which represents property service workers throughout the state, including janitorial workers. And in 2015, as the union was working on a legislative campaign regarding wage theft, they learned from one of the very outspoken leaders and janitors who worked on that wage theft campaign and who has been a member of the union for many, many years, shared that she had experienced sexual harassment at the worksite. That was in 2015. And it was surprising to many of the organizers and staff of the union, because this was a member who was not afraid, not outspoken, and had never shared this experience until they were able to spend more time together working on this wage theft campaign. Around the same time, in June of 2015, PBS and Frontline issued a documentary called Rape on the Night Shift. And that project told stories of janitors who said that their supervisors had exploited them and had used basically the solitude of the night shift to harass them and assault them while at work, while their employers looked away. After learning this information about what this member had gone through in terms of sexual harassment and assault, and after watching this documentary, the union was around the same time preparing for contract negotiations. And typically what the union does prior to beginning contract negotiations the year before is that the union sends out a contract survey. Next slide, please. Next slide. Thank you. And this time the union decided to include sexual harassment as a question in terms of issues that workers may want to have addressed in preparing for upcoming contract negotiations. And approximately 5,000 or so janitors responded to the contract survey, and it was surprising to the union and a big concern that the top third issue for janitors was sexual harassment. And approximately half of the janitors who responded to the survey stated that they had been sexually harassed at work, and about a quarter of those who responded to the survey stated that they had witnessed sexual harassment at work. And so this became very concerning issue for the union. And as you see on the slide, the quote from the Secretary Treasurer of USWW, it was alarming that a union that represented predominantly immigrant janitors, 70% of whom were women, that they were dealing with this issue, and the union certainly decided that it was important to take action to try to improve the situation in the industry. Next slide, please. So as part of the thinking about changing the industry, I mean, as most folks know, California has some of the most protective laws when it comes to labor and employment, including sexual harassment. And for example, California law requires all employers to provide required training to supervisors if they're employer of 50 or more employees about sexual harassment, about how it's unlawful. And there are very strict laws with respect to supervisors who engage in sexual harassment and liability on employers. But it was clear that irrespective of the laws that exist and these training requirements that exist, that nonetheless, it wasn't getting to the issue about sexual harassment and assault and violence at the workplace. And so in 2015, the union created a coalition, which it called Ya Basta in Spanish, or Enough is Enough. And it was formed with other partners along with the union and the Maintenance Cooperation Trust Fund, the East LA Women's Center, the California Coalition Against Sexual Assault, otherwise known as CalCASA, and many others, came together to talk about ways in which they could together work to change the industry. They created and talked about worker and member education, empowering workers, and they created this training for janitorial members through a model called the Promotora model, which is a nationally recognized empowerment model that comes out of the domestic violence movement. And so the idea was to bring all of these forces together to find ways to do dramatic change to the industry. Next slide. In addition to that, next slide. In addition to that, the union, with its coalition partners, decided to start, yes, that's fine, thank you, to work on both a contract campaign that addressed these issues of sexual harassment on the workplace, as well as a legislative campaign. And the contract campaign which incorporated the Yabasta campaign, resulted in janitors highlighting the experiences that the workers suffered of sexual harassment at work. And in 2016, the union was able to settle its contract, and in that contract, it included special provisions regarding sexual harassment and assault. And it covers, the provisions cover many of the items that Kachin touched upon in terms of the type of contract language that unions can negotiate into contracts to provide further protections for workers from sexual harassment and assault. This included describing and defining what unlawful sexual harassment is in the workplace and what unlawful sexual harassing conduct is. A specific process for reporting complaints of sexual harassment, including instituting a hotline for employees to report and seek help for sexual harassment. It includes, and there are many provisions, I'm not going to go through all of them, I'm just going to highlight a few in terms of the language that the union was able to obtain in its contract for janitorial workers. For reports involving third parties, and these are individuals that are not employees of the employer, for example, a building tenant or a visitor, the employer is required to forward copies of any complaints involving sexual harassment by a third party to the property owner or property manager and request that they take immediate steps to correct the issue. The employer is also required to take steps to ensure that a victim has no contact with an accused harasser. There are additional training requirements, including orientation for new employees that require providing information and training on sexual harassment and assault, and additional training requirements for the employers to provide union members on top of those that are required under state law. And it details in the contract the type of topics that are to be included in that training. In addition to that, it requires the employer to maintain and document trainings that it provides to its employees and supervisory personnel. And it requires the employer to adopt and implement a workplace sexual harassment and assault prevention plan, as well as to maintain and distribute to members a list of organizations that can provide assistance to sexual harassment and assault survivors. It also requires employers to provide victims of sexual harassment or assault time off to be able to seek any assistance that's needed. And finally, the contract prohibits employees with supervisory authority from engaging in any sexual or romantic relationships with a subordinate employee. Next slide. As I mentioned, there was, in addition to the contract campaign in 2016, a legislative campaign in California. And Assemblywoman Lorena Gonzalez Fletcher decided, after seeing the documentary Rape on the Night Shift and meeting many of the janitors, decided to seek a legislative response to the sexual harassment and assault that was rampant in the industry. Next slide, please. And in 2016, Assemblywoman Gonzalez Fletcher introduced the Property Services Worker Protection Act, AB 1978. And the bill would require janitorial contractors to register with the state. To support the bill, the janitors testified about the violence that they had experienced at the workplace. They demanded public attention through billboards and dozens of marches and signs that read, "Ya basta." Next slide. And in the fall of 2016, as the bill went through the legislative process and was pending, sitting on Governor Brown's desk, waiting for it to be signed, for a week, a dozen or so janitors staged a hunger strike in the lawn in front of the California State Capitol. Promotoras and worker advocates stationed themselves near the State House to put pressure on Governor Brown to sign the bill. It was, as I mentioned, a 5-day hunger strike. And on the afternoon of the 4th day of the fasting, Governor Brown signed the bill. That was on October 15, 2016. And so what the bill does, as I mentioned, is that it creates a registry that requires janitorial contractors to register with the state through the Department of Labor Standards Enforcement. It places other requirements on janitorial contractors, including keeping accurate records of the names and addresses of all employees who are rendering services, including the hours worked, the wage and wage rate paid to each employee per pay period. The registration is to be done annually with the California State Department of Labor Standards Enforcement. And employers who do not register with the state are subject to penalties. The law also requires and establishes a biennial in-person sexual violence and harassment prevention training for employees. And the Department of Industrial Relations and the Department of Labor Standards Enforcement are presently working on the content of that training, which is to be put into place by January 1 of 2019, that's next year. In addition to that, the law can refuse to register or renew the registration of a janitorial contractor who has failed to satisfy any judgment for unpaid wages, or who has failed to remit the proper amount of contributions to the unemployment insurance, or has engaged in other malfeasance with respect to Social Security and Medicare tax contributions. Finally, the law also has a successor liability. So a successor employer is liable for any wages and penalties that a predecessor contractor owes to former employees if they use the same or substantial same workforce and they share in the ownership or control of labor relations of the business operations of the predecessor employer. Next slide, please. So really, we just wanted to make sure to highlight that this campaign, both the contract campaign and the legislative campaign, was really about workers changing the industry, that the janitors and the promotoras came forward to tell their stories, to educate fellow members. And in fact, the new legislation, there is new legislation that the union and the promotoras are currently working on to improve the training that is required for employers under the janitorial registration bill, the AB 1978. And the new legislation would require peer training so that janitors who have experienced this type of sexual harassment and assault would be able to come into workplaces to provide this type of training to janitors in the workforce. And that law is called AB 2079, the Janitor Survivor Empowerment Act. And so the workers continue to do education and training for themselves and other workers in the industry, including on what is sexual harassment, what is sexual assault, self-defense, and ensuring that that members in the industry understand what sexual harassment and assault is, and that they can change this by understanding that this is not tolerated, and deconstructing patriarchy within the industry and culture in families and in their organization. And that's all I have. Thank you.
Thanks, Monica. Next slide. And Jeremy, thank you so much.
Thank you. And thank you, Monica, because really the work that you all did in the Abasta Coalition and with USWW gave us the inspiration and the model to do what we've done here in Oregon recently. So following the passage of AB 1978 in California, last year in 2017, here in Oregon, with thanks to the testimony by janitors, including one very brave member of ours who went public in the State House about her own sexual assault, we were able to get past HB 3279, which does a lot of things similar to the California model. Except it's based on some existing statutes that were licensing programs for labor contractors, first in the farm worker and forestry industries, and then more recently in construction labor contractors. So So although sexual harassment and assault were pretty central to our campaign and were an important part of the legislation and how we framed it, both our campaign and also the law that resulted and the new requirements that we have are also framed around wage theft and discrimination. So what we've won includes two parts. There's the licensing program, which we refer to as a registry, similar to California. And then there's also the training program, and I'll talk about those two parts. So comparable to what's being implemented in California, in order to provide janitorial services as a contractor, all companies are required to have a license now through the state labor agency, BOLI, the Bureau of Labor and Industry. And so that covers anyone who's recruiting, soliciting, supplying, or employing workers in janitorial services. This licensing requires a few things, which we see as tools to hold employers accountable. It includes that they have to make significant disclosures to the state labor agency through their license applications, including the ownership of the company, which, as we all know, sometimes can be hidden behind LLCs and things. Judgments and final orders of any violations of law of the last 5 years. They have to show proof that they're up to date on their workers' compensation insurance and taxes. That's at the outset when they first apply for an application. And then every year upon renewal, then they also have to disclose their worksite locations, the total number of employees they have in the whole company, and the training materials that they have used around the professional training that I'll talk about in a minute. In addition, companies are required to maintain their own records and submit to the state labor agency on demand their list of subcontractors and also certified payroll records. The training, so the training is similar in some ways to California, but it's also it's about sexual harassment and assault, but also goes further into preventing discrimination and promoting cultural competency and knowledge of whistleblower rights. Next slide, please. And actually, I think I've already covered this slide. Could you go to the next one again, please? So every employer is required to give this training within the first year that it's got since its implementation, and it went live January 1st. And then for all current employees, for all new employees, they have to be trained within the first 90 days of employment. And then subsequently, then they have to do refresher trainings every 2 years. It has to. We tried to win what you got in California, which is that it has to be an in-person training. Unfortunately, we didn't win that. But what we got was it either has to be live, or if it's a webinar or some kind of like a webinar, there at least has to be an assessment demonstrating that the person doing the training is following and can answer some questions. The training has to include definitions of harassment, assault, and discrimination, the employer's specific strategies and policies for preventing the discrimination, assault, and harassment, and how to handle complaints. The training has to be provided in a language understood by the workers. So that either the training has to be provided in that language, or they have to use a certified interpreter. And also, one modification that we negotiated was one of our major employers that are signatories to the master janitorial contract is what in Oregon is called a qualified rehabilitation facility, and employs primarily disabled workers with disabilities. And so there is language in the statute and the rules that say that in the case of those nonprofits that primarily employ people with disabilities, they can make modifications to the training for the cognitive and other abilities of the workers themselves. So now we're in the phase of, well, I said the law has been in effect since January 1st, but it's the enforcement will not begin until mid-year, until July 1st. Thanks for jumping to the slide. BOLI the state labor agency can fine employers for providing janitorial services without being a licensed contractor, and can also fine clients. They can actually fine customers for knowingly using a janitorial contractor that's not licensed. Any person can bring private legal action against an unlicensed contractor, and if they prevail, to get back the attorney fees. And workers have private right of action for wage violations plus attorney fees. And also a key part is that the employers and clients are personally, jointly, and severally liable for wage violations. So all of that goes live July 1st. And as to conclude, as we're getting ready to launch the trainings, we're designing trainings ourselves. We expect that BOLI will offer some of the larger employers will probably offer their own, as is allowed by law. But we're interested in actually creating a training that we think that some of the smaller employers will want. And so now we're looking to developing relationships with allied organizations that are advocates, to stop domestic and sexual violence, especially building in a trauma-informed approach to providing those trainings. And we know that, we expect this will bring some survivors forward. And so we're also developing ideas for how to train our staff and our rank and file leaders about how to refer survivors to organizations that can support them. Thank you.
Thanks so much, Jeremy. Sonia, you're on.
All right. Thank you, Debbie. So first and foremost, thank you and congratulations to all of you who have been joining us through all these series of webinars, our presenters that are doing amazing work. And I just want to make sure that you all know that you're not alone in doing this work. If we can get to the next slide, please. There is not one solution or one agency or one organization that will by itself respond fully to preventing and eradicating workplace sexual violence. And this is why we must create a meaningful systemic and cultural change to reduce forever gender violence in the workplace. So as you can see, this matrix is just an idea. It just offers a blueprint for you to think as you're coming from different backgrounds, how to build change and how to build systemic change that will endure forever and that will make things happen for survivors. So as you look at the matrix, just think about what are your own strengths? What can you personally bring to the table? What can your organization, collectively, your agency bring to the table? And how can we become stronger by identifying what others can do well with us? In so many chaotic situations, we have found ourselves competing with competing interests, and we need to stop and think of each other as allies. I remember in the case of Postville, how crazy it was to have the union, diving in and talking to some clients and not talking to the other service providers and the immigration lawyers and the advocates. And it was pretty chaotic. And it was because we were not thinking straight. We were not thinking of each other as allies and as, pieces of the puzzle that we could build on to, with strength and collaboration, tackle what was happening to the survivors. So as you identify survivors, as you get all these ideas and information that you learned today through the past 2 months, please remember that every case is an opportunity to change the system and make it better, if not maybe perhaps for the one that you're working because you're breaking barriers, for others that are going to come forward because the amazing work that everybody is doing, including yourselves. So view every challenge as an opportunity to create change. We all know how burnt out we are, how little resources and how little time we have. And this is why, again, partnering with key allies before the crisis, happens, before the cases come to you, before you identify your cases, will strengthen the opportunities for success, for women to have voices, and see women as partners and allies, not as pobrecitas victimas, because they are stronger and resilient, and they will partner with you and do the work with you so you don't have to do it for them. So as you continue the work, do a self-assessment of your work and organization. Again, what are your strengths? What are your weaknesses? And don't be embarrassed about saying, hey, this is a long, long laundry list of weaknesses. And learn, how do you can help, and how can you be helped? What are the challenges in doing the work? For instance, sometimes the direct action and need for privacy seems to conflict with this tension. And see this as a space for perhaps developing creative organizing tools to combat workplace sexual violence collectively. Remember that you're not alone again, because you can feel very lonely, in the middle of a case or a mountain of cases, and that there are many resources available. The next 3 slides are full of national and local resources. You can contact our speakers with questions and cases. You can use the guide that Maria sent to you before the webinar, and that we can also, send again to you with very good ideas for models. This tool is the really great example of what happens when everybody sits down at the table and brings the best of each and every one of us, experts in the field. So this guide is a collaboration of advocates, sexual violence and gender violence advocates, immigration advocates, and labor advocates and organizers. And it has tons of models and promising practices that you can check and then go back and create your own. So break ground and open doors, so one day we do not need to have these webinars anymore. And lastly, I really want to commend ACIU and Debbie for being a daredevil and allowing us to partner with you guys and to share this information. And I hope that we can continue to collaborate in the future.
Thanks so much, Sonia, and thanks so much to everybody for speaking. It seems appropriate that this is International Women's Day, and we're celebrating it by learning more about what we can do to help the survivors, immigrant survivors of sexual violence. So thank you so much to everyone, and look forward to being in touch in the future. Bye.